Today on Hashtag Lawyer, we're going to tackle abortion and Roe versus Wade. Big controversial topic, especially with the confirmation of Justice Barrett. And we're going to go into the intricacies of what actually the Supreme Court said about the case and what the future holds with our new Supreme Court justice. Welcome back to Hashtag Lawyer. Today we're going to talk about something that's highly political, but also in our professions, it's pretty fun to jump back into a Supreme Court opinion and really dissect it and go through what did they say and what does that actually mean, how did they get there, and what does this mean for the future?
Y'all, you know how much I love Supreme Court dissection. Opinion dissection, obviously, not the justice.
Yeah. Well, and what's funny is, I didn't say this before the show, but like when we were going through and preparing for this, I had flashbacks to law school, going back in, briefing a case, going through it, figuring out, okay, they're going to talk really long-winded about something that doesn't matter here, and go to, all that kind of stuff. And so that was, kind of nostalgic for me a little bit, because it's been
kicking it back to the good old days.
Yeah, because it's been almost a decade since I've been in law school.
Really?
So, oh yeah.
Oh, you don't look it.
Well, I appreciate that.
Yeah, well, it's the powder I give you.
The beard helps.
I'm still, I said it the other day when you announced No Shave November, I think it's called. I still don't know how I feel about the beard.
Yeah. What's funny is Mom hasn't seen it yet, but she heard you say that on the podcast.
Did
and
she
she's
really?
like, I don't know what to think.
Oh my goodness.
So we'll see what happens there.
I know. I think I just need to see you with the beard like 5 more times, and then maybe I'll have an opinion.
Okay, there you go. So for those of you who hadn't heard about Roe versus Wade, it's the actual Supreme Court case that everybody says legalized abortion. It didn't technically do that, but that's what everybody says. It's what it's known for. Really what it did was decriminalize abortion is really what it did. So
there's a difference.
There's a big difference.
There's a huge difference between decriminalizing and making legal.
And you and I are going to be more particular about those types of things because it's part of our jobs.
Yeah.
You get into and you figure out, okay, what does this actually say? What are the words actually, what's the importance of that? And we're going to get into some of that here.
Yeah.
And what does it actually mean? So big picture, legalizing versus decriminalizing, practically speaking, kind of applies similarly to the way the policies are put out. But it's different though, and we've seen why it's different whenever you look at how the abortion laws and the Roe versus Wade opinion has changed since it was issued by the Supreme Court. So let's jump right in. I'm going to give a short synopsis of what happened. And I'd forgotten that this case actually really, it was a Dallas case. Yeah, it started here, a woman in Dallas. Wade was actually the district attorney's name, Henry Wade at the time. And so I'd kind of forgotten about all of that, which is kind of crazy.
Which is fun, because we talk about this podcast as like trending news and law and business in Dallas. And, look, one of the biggest decisions in Supreme Court history started here in Dallas.
Started here. So you got a pregnant single woman, Roe. She brought a class action suit challenging the constitutionality of the Texas criminal abortion laws. And back then those laws said you could not get an abortion in Texas unless it was the product of rape or you were trying to save the life of the mother. So none of this, now we have all these different ranges, that kind of stuff.
Yeah.
None of that. Can't do it. You can get arrested for it. So she files suit. And there's a couple other plaintiffs that join it, but really her case is the important one that kind of steers this whole deal. And basically, at one point she actually tries to claim that she was raped, tried to play that off.
Oh, I forgot about that.
She did. She tried to, because she couldn't get an abortion otherwise.
Yeah,
and
that's
so
right.
She tried to claim that, which in today's society is insane to think about, that someone would have to do that, to be able to make this choice. I think I just tipped my hat on where I fall on this on this spectrum here. But she basically filed a federal lawsuit. She was going to get prosecuted for a state crime here in Dallas. She files a federal lawsuit asking the court to enjoin or stop the state from prosecuting her. So unique situation.
Very.
She's basically saying, look, this statute, this law is unconstitutional. And so I need you, federal government, court, to tell federal government to stop these guys, stop Henry Wade, the district attorney, from prosecuting
the Dallas DA.
Right. So this case makes its way up to the Supreme Court. And the question is the law preventing or prescribing or prohibiting abortion unconstitutional?
The big money question.
Right. And there have been some challenges to this before, and this always happens Supreme Court level. Usually you've got something that if it doesn't hit squarely on the issue.
Yeah.
It dances around it a little bit at least, and then you finally at some point we get to, okay, this is the seminal issue. It's going to be decided, and I know you and I will get into the reason it moves slowly like that and why that's important.
You know I love that.
I know. I'm going to let you take the wheel on that part. But the interesting thing too is, well, let's go to the main opinion. The main outcome of the opinion, then we'll kind of backtrack through it, is that the Supreme Court said that a person may choose to have an abortion until a fetus becomes viable based on the right to privacy that's contained in the Due Process Clause of the 14th Amendment. The court defined viability as the fetus's ability to live outside the womb, which usually happens between 24 and 48 weeks after conception. And so so based on that, the Supreme Court said this law in Texas that just says that you can't have an abortion, it's too broad, it's got to be narrowed, and it's unconstitutional. You got to come up with a new one that still allows the woman to have an abortion under certain circumstances, which we'll get into as well.
Yeah.
So the first thing I wanted to jump into was, how did they get there?
It's a long, windy road.
It is. And if you read the opinion, which you can find these opinions online.
You don't even need Westlaw, guys.
Right,
just Google it.
Right.
It's on the Supreme Court website, I think.
It's interesting to me. The main justice who wrote the opinion spends an inordinate amount of time going through the history of abortion, why it was there. I mean, the funny thing I thought was that, okay, it's safety of mom, obviously safety of the fetus, that's part of the reason, but the old school policy to discourage illicit sexual conduct. Which obviously, if you have abortion laws, we're not going to have illicit sexual conduct. People are not going to commit adultery. They're not going to have sex out of wedlock. Like, that's obviously not going to happen, right? Because that's.
And you know, if you're married and you get pregnant and you already have 4 children and you got pregnant accidentally with your husband's child, but you can't afford to feed your child, that would never happen because you, as the woman, would make sure it didn't happen. Like.
Right. Well, because that's illicit sexual conduct.
Because obviously, even though it's with your husband, gosh.
So it was interesting to read that, and then it was extremely interesting, in my opinion, to read as they went through. They talked about, well, in the Jewish faith this, in the Protestant faith this, in the Catholic faith this. I was like, well, that's kind of dancing around the First Amendment a little bit, but I mean, they were trying to. I mean, they didn't do it in a way that was disturbing, but it was in a way of like, well, let's just get some context here.
It certainly raised some eyebrows, I would say.
Yeah, it did. So anyways, that was interesting. But what they end up going into is, okay, we've got the 14th Amendment, which, as we talked about in our previous episode, that it deals with the Equal Protection Clause and the Due Process Clause. There's 2 different clauses in there. It came about through the Civil Rights Act.
Yes.
Or the Civil Rights Movement.
Yes, I was about to say, Civil Rights Act, Title VII is a little different.
Different. Civil Rights Movement. It came about through that.
Certainly.
And I wanted to talk a little bit about what the Due Process Clause is, and then kind of explain to our listeners how they pulled the right to privacy out in that. And so, kind of in your words, Andrea, what is the Due Process Clause? What does that mean?
Absolutely. So the Due Process Clause states that somebody's fundamental right? So for example, the right to privacy cannot be taken away by that state without a process that allows for the person losing the right to be able to put on a case with evidence and present it.
Right. And that's the process, that's the due process that goes into giving them a chance to defend that fundamental right.
Right, and this applies, right? The idea of due process applies across a wide spectrum of things.
It does.
For example, and I think a lot of people don't think about this, if you have a high schooler, right, public school, who is about to be expelled for allegedly cheating on an exam or something, that child still has rights, and there has to be due process that's followed where the child is allowed to essentially put on a case to defend him or herself and put on evidence against the school that's accusing him or her of these things. So there's a process even in that very, very different and much, it's a big situation, but not as big as, abortion. Right. But even there, you see that due process does apply.
And I think schools are the best example of this because you can look at employment contracts with schools. You can look at expulsions. You can look at, punishments and suspensions even. And there has to be something in there where there's due process. Now, it varies. So like if you're looking at a sexual assault allegation that invokes Title IX and some of the other issues that are going on right now in a lot of our college campuses, it's going to be a much higher requirement of due process versus 5th grade kid gets into a fight at school and gets suspended. they're probably not going to challenge that, quite honestly. But if they did, there would have to be some kind of a investigative process.
Procedure.
Yeah, something there. And that's, we won't get into all this. That's different than if you're dealing with private institutions and private companies, all those types of things. So totally different situation. And so fundamental rights, there's some people think, okay, well, it's my fundamental right to drive. Well, no, it's not.
No.
You have to apply to get a license. You have to apply to do those things. Fundamental rights are things that, and these are in the foundation of our Constitution, things that they're inalienable. You are born with them because you live in this country, that type of deal. So freedom to marry, freedom to have a child, freedom to vote. And that's actually a good example of a fundamental right that can be taken away through due process if you are convicted of a felony.
Which there's a lot of controversy around that subject, and those laws are changing in certain states, but that is a great example of how you can lose an inalienable right.
Right. And the due process part of that is the trial.
Exactly.
That's the ultimate form of due process under our constitutional standards.
Of course.
And so, as you mentioned when you first were talking about the due process clause, privacy, the word privacy is not in our Constitution. It's not in our Bill of Rights, not in any of our amendments. But the court has found over time that privacy is one of those rights, right?
They found it because it's been in I think they use the phrase, the penumbra of the Constitution, or the penumbra of the 14th Amendment.
Good word.
Well, isn't that in the opinion?
It is.
Yeah, that's what I thought, right?
Yeah.
So it's like when you look at the sun and you see all the squiggly lines around the sun, that's like the penumbra.
Right.
My very scientific explanation.
Yeah,
but
absolutely. And so the court had, prior to this case, had found that privacy was in the penumbra of the 14th Amendment. And so it was one of those fundamental rights.
And I think that's really important for people to understand that they had found this right to privacy prior to Roe versus Wade, right? A lot of people, get upset when they discuss this case with me because they say all of a sudden out of nowhere, bam, the Supreme Court says there's privacy. There's no privacy in that Constitution. I believe that the Constitution is just a document and you have to strictly interpret it, and because the word privacy isn't in there and they just randomly threw it in there, that's wrong.
Yeah.
Okay, well, I understand where they're coming from. I think they're coming from a good place of wanting to, abide by our founding document.
Yeah.
I respect that opinion, but I don't think they're aware of the facts that actually privacy has been found previously.
Yeah.
This is not something out of the blue that just came up in Roe versus Wade.
Well, and for fear of going, or in spite of the fear of us going off on our tangent too early, but kind of as a teaser, I mean, that's part of what people need to understand, that the way that we get to these big landmark decisions, it's on the shoulders of previous decisions. It's a stair step, it gets there.
Step by step.
And so like what you were just talking about, there are numerous cases, and the reason people didn't hear about them, because they weren't talking about stuff that everybody was real excited about.
It wasn't real sexy stuff.
Exactly. It was, actually, I don't even know the cases that it talked about because I didn't memorize them, but the times where they were talking about privacy does invoke the 14th Amendment. Those were, decades before, maybe even longer, than before Roe versus Wade. And so on those less sexy opinions, they figured out what privacy means, and then they're bound by that to have to interpret it precedent in this Roe versus Wade opinion. And so yes, you're absolutely right. It's a great point. It didn't come out of nowhere. It came off the shoulders of previous opinions. And so they basically, court ended up saying that by prohibiting. Prohibiting.
Pro-PRO.
Yeah. By prohibiting an abortion, you are taking away a woman's fundamental right to privacy without due process. And so that's how we get to the point where you can no longer do that.
And so see, at the end of the day, they're not saying, well, abortion is legal. They're saying what's not right here, what's not okay here is this withdrawal or taking away of the inalienable right to privacy without giving her that process, without giving her the ability to have a trial or to put on evidence, without giving her a procedure to say, no, I should not have my right taken away. So that's a lot more narrow than people actually think.
It is, and that is exactly why the court left open the idea that the state can regulate in certain aspects of it. Because they didn't legalize abortion, they decriminalized it.
Exactly.
And the other part of this, and this may be lost a little bit, is that they decriminalized it because the law of you can't have an abortion is too broad.
Exactly. It's too broad because it's just taking away wholesale your right without any form of process whatsoever. So I know people get really upset when there are different states, mostly in the South, that regulate abortion because that those constituents feel a little bit more strongly about it than certain other states, and that's fine. Everyone is entitled to their opinion, and I believe you should have your own educated opinion. That's wonderful. But it's not wrong per se for a state to say, we're going to put regulations on abortion. They're completely within their right to do so.
They are.
And I mean, Roe versus Wade is not limiting that. In fact, I frankly think it's encouraging it.
Yeah, it is. It is, because it left the space open for them to come in and do it. And so that's the next part of what we were going to get into, is that it's not an unfettered right. State, and the court said that the state has an interest in regulating medical standards and to regulate health, and the state has a duty to protect its citizens, whether that's the mother and the viable fetus at a certain point. And so basically what they ended up saying is that the state may regulate during the following periods, from the first trimester to viability. The state may regulate abortions in a procedure that is reasonably related to maternal health. And then from viability on, the state may regulate or prohibit abortions except when necessary to save the mother. And so basically what that turns into is that you've got the state at 24 weeks and moving forward, the state, 24 to 48, the state can make regulations and certain requirements.
Sure.
And then after 48 weeks, the state can prohibit it wholesale.
Yeah.
And so it's allowing, like you said, it's encouraging the state to put some other restrictions in there that, that further the state's interests while not infringing on that fundamental right that the mother has.
And it also allows the people within the state, right? So if people in the state of Texas really feel a certain way about abortion in that 24 to 48 weeks period, they can vote for people that reflect their views.
Right.
And so I think the Supreme Court was encouraging people to speak up about issues like abortion that really matter to them, and to vote their conscience for representatives and senators to represent them, because your legislature makes the laws, the courts just enforce it.
And that's, when you read big Supreme Court case opinions like this, everything you just broke down, it's so impressive that they're able to go through and think about those things.
Absolutely.
Because what they did, they basically said, look, you can't do this because you can't criminalize abortion and just prohibit it because you're infringing on constitutional rights. At the same time, we know that every state's different, and so we're going to allow the constituents of that state to figure out and vote for their senators and congressmen and women who can put in whatever restrictions they want to put in there, as long as it doesn't violate these fundamental rights that we're talking about. And so it allows for some play there with the state, with each state doing something different.
Yeah, and I just want to really emphasize the nuance of these decisions, right? Because so many people say, well, it's a fundamental right. A woman has a fundamental right to an abortion because it's her body. That's a complete misreading of Roe versus Wade. That's not true legally, as a matter of fact.
Right.
And it irritates me when people say that, because this is a very important issue.
Yeah.
And depending on your perspective, there are one or two lives involved, however you view it. And so I think that the least thing that we can do is be knowledgeable about what the actual opinion says, and when we discuss it, be mindful of what it actually means, not jump to these wholesale conclusions.
Yeah, well, because the thing that always pops in my head when I hear that it's a woman has a right to do what she wants with her body. Well, the Supreme Court ain't saying she can go do heroin, so that's not what they're not saying. She can do whatever she wants with her body. Okay?
Exactly.
Prostitution's not legal.
Except in what, Nevada?
Nevada, yeah. But in Texas or most places,
in Texas, it's
federally
not legal.
It's not legal. You know what I'm saying, though.
Yeah.
There's not. No one's been able to strike down the Texas prostitution statute.
There you go. Yeah. So that guys, just it's not true. A woman does not have a fundamental right to do with whatever she wants with her own body.
Right.
You can't do heroin. You can't be a prostitute. So on and so forth. Not in the state of Texas.
Great analogy.
Men can't do it either.
Right. So another thing that's interesting about this that really jumps into some of the controversy that you see on some of the moral arguments that people make is that the Supreme Court also concluded that a fetus is not treated as a person when applying the Constitution.
Which is very interesting.
It's huge because if they were, because actually, and this is something, again, law nerd stuff that I enjoyed reading the opinion, is that in the opinion, the Supreme Court said that the people representing Roe had to admit in argument that if the fetus was treated as a person as defined by the Constitution, then their argument for this entire case fails.
Absolutely.
Because that person then has the fundamental due process rights not to have their life taken from them.
Exactly.
Without due process.
And I think that's so interesting, and we'll probably have to save that discussion for another time because we can really, really go into it.
Right.
But that brings up the question of how do you determine when the fetus is a person?
Yeah.
And that I do think has a level of subjectivity that has not necessarily been scrutinized by the courts because there hasn't been an appropriate test case for that.
Right.
And I would be very intrigued to see what that test case looks like and how the court eventually rules on that, because I mean that is the bedrock to this entire issue of abortion. Is when is the fetus a baby and the baby's a person? Right.
And you're going to get extreme opinions on either side, whether that's pre-viability is still murder or not. You know, that's people have very strong opinions about that, and that's the important thing, is that the Supreme Court at this point has said a fetus prior to viability, not a person, doesn't have the same rights legally under the Constitution that the mother has.
Yeah, and viability we said was 24 to 48 weeks?
Yes, ma'am.
Okay.
Yeah, so 24 weeks basically is when we're talking about that. So since Roe versus Wade was decided, we've had two major cases that challenged it, and typically these cases come in the way of, and I think this will be a great way to set up how we talk about precedent and how it works. Typically these cases, or not typically, these two cases have come on the issues of, is a regulation unconstitutional? So not you know, criminalizing or making it illegal, but is an extra restriction in that 24 to 48 week period, is that something that is basically unconstitutional because it's restricting this right?
This ability, is it unconstitutional because it's restricting the woman's right to obtain the abortion without giving her sufficient due process?
Right, exactly. Well said, thank you. Saved me on that one.
Anytime.
First one was Planned Parenthood versus Casey, 1992. Supreme Court upheld a woman's right to choose. This is the way it's basically paraphrased.
Yes.
Basically all that happened in this one is that the Supreme Court went from using the term trimesters to just strictly viability and went to the 24 to 48 week period. Really didn't do anything to change what's going on. It just said, okay, we're going to narrow this definition and we're going to be more specific about it. So started there. 2016, most recently, more people will probably remember this one.
And it's another Texas case.
It is, yes, that's a great point.
Yeah.
Whole Women's Health versus Hellerstedt. It's Texas law, and I remember about this because it was kind of insane when you started really looking into it, and you could see the wheels turning in the legislature's heads of, okay, well, you know, we're not going to say it's illegal, but we're going to make it very difficult to get an abortion in Texas. Basically, what it said was Texas-based law required a physician who was going to perform an abortion to have what's called admitting privileges at a hospital that was less than 30 miles away. Well, the problem with that, because I remember analyzing this, the problem with that is that most hospitals, to have admitting privileges, you've got to, typically be an employee of the hospital and be treated like one. Well, hospitals have their own doctors. They're not going to let some outside doctor.
Or they have an independent contractor relationship with a particular physician's group, right? For tort reform reasons.
Sure. But, you know, Dr. Smith down the street, who doesn't have that relationship, well, he can't perform abortions at his clinic anymore if he can't get that relationship. And if they don't want that because they've already got this one, well, okay, he can't.
Or maybe they don't want it because it's a religious institution hospital and they, you know, on religious grounds, they're opposed to abortion, so they as principal will not give admittance privileges to someone who does do abortions.
Right.
And that's completely within that hospital's right. It is their First Amendment right to practice as a private hospital based as a religious institution to say, we want to uphold our religious values and are not going to admit doctors who practice abortions.
Exactly.
Their First Amendment rights.
And so if you couldn't obtain that because of the scenario you were just talking about or a number of other different scenarios, you could no longer perform abortions at certain clinics. Well, the result was the number of abortion clinics went from 42 to 19. And so the Supreme Court ruled that you can't create a law that places an undue burden on a woman to get an abortion.
And there's that phrase, undue burden.
Right.
That's important, y'all.
It is because what you're doing at that point is if you're creating that undue burden, now you are making an overly broad statute that is unconstitutional because it infringes upon a fundamental right without due process.
Sufficient due process. Yes, there we go.
So states have been able to uphold certain restrictions like parental notifications for minors and mandatory disclosure of abortion risk information at clinics, and then restrictions on late-term abortions like we were talking about.
Yeah, so like generally third trimester.
Right. So it hasn't been full wholesale. And so it's interesting to look at this and look at the cases that led up to the Roe versus Wade decision. And this is going to segue us into our conversation about Justice Barrett, who was just appointed on the Supreme Court.
Congratulations.
Yeah. I doubt she's watching, but
well, if she is.
Wishful thinking.
Well, I'm going to manifest that into the ether.
There you go. I'm on board with that. A big concern about a big deal in the confirmation hearings, in the public, is, okay, well, is she going to overturn Roe versus Wade? And I know this irks you so much.
Yes.
And so what we want to talk about a little bit is the impact of judicial precedent and how slowly or how long it takes to actually change laws through Supreme Court action. So let's kind of talk generally. What's the best way to explain what precedent is to our listeners?
I think we touched on it earlier, and the idea of precedent is that there have been a body of case law going way back that have dealt with a particular issue, and then cases build and build and build while being consistent with how the issue was ruled upon in the prior cases. And generally, depending on the level where that case was decided, let's make it really easy. Let's say you have a Supreme Court case. They have ruled X back in 1942. And generally, for the most part, they are going to uphold the ruling of X from 1942 to the present day. And they may tweak it. They may narrow it. They may change it a little bit. But it's not going to necessarily be overturned unless there's some sort of severe fundamental reason to overturn it. Like, for example, what we saw with Brown versus Board of Education.
I was literally just thinking about that. Right.
So you had massive substantive social reasons.
Huge swing,
complete 180 for a very good reason. Okay. And some people, I'm sure, might say that there is a really good reason to completely overturn Roe versus Wade, because they believe it's murder, and completely within their right to believe that, and I absolutely understand that from the religious perspective. But to be fair, this issue is very different than Brown versus Board of Education.
It is.
Right? Because you are, the court has established a precedent of the fetus is not a person up until 24 weeks.
Right.
Okay? Whether it's good, bad, wrong, right, however you feel about it, that's what the court says.
Yeah.
And if that's what the court says, that means that all of these protections that would apply to children, right, in Brown versus Board of Education, that fetus is not a person, is not going to be getting those rights.
Right.
And so you have a completely different concept than Brown versus Board of Education. So you're not going to have all of a sudden on the court one day, a test case pops up and all of a sudden, boom, all of the case law and precedent surrounding Roe versus Wade is overturned and nullified and void. That's just, it's not going to happen.
Right.
And also for a case to even get to the Supreme Court, it takes a very long time. And cases that do reach the Supreme Court generally have very clear fact patterns.
Right.
And the court likes clear fact patterns because it allows them to make oftentimes very procedural rulings. Because you'll notice that the Supreme Court didn't say in Roe versus Wade, abortion is legal. We discussed that.
Right.
It decriminalized it.
Right.
And it went through a very lengthy discussion about procedure and due process. The Supreme Court loves procedural rulings.
Yeah.
They love to make their rulings based on procedure. They're not going to turn around and say, we believe it's immoral to have abortions, so abortions are flat out illegal. That's just never going to happen.
Right.
I think.
No, I agree, and I've got about 16 different thoughts right now, so I'm going to try to narrow them so that we don't go crazy. But so going back to the Brown versus Board of Education, I think looking at that case and looking at the case, and I don't recall the name, but this made separate but equal. The Jim Crow laws separate. They said that separate is not equal. Is basically what they ended up saying, and that was a huge pendulum swing the opposite direction. That. And then I believe the gay marriage laws. Yeah. Those are two cases that pop up in my mind that were some of the biggest pendulum swings we've ever seen.
Obergefell for gay marriage.
Right, okay. And so, because I remember there were some, maybe they were critics, maybe they're just analysts, but saying that it was surprising that they just outright legalized gay marriage, because they expected to see a little bit more of a stepping stone to get there.
Yes, I do recall that because, like we said earlier, the case proceeds oftentimes, for their detractors, at a glacial pace.
Right.
But we live in a federalist society.
We do.
And so, honestly, making massive policy changes or I shouldn't say policy changes, that belongs to the legislature, making big changes in terms of procedure within the legal realm slowly is frankly a good thing, because it prevents the entire legal system from being thrown into upheaval.
Right.
And guys, the Supreme Court doesn't have an army.
Right.
It's
their power is their orders.
Their power is their orders.
Yeah.
We obey the Supreme Court because we all realize that that is the law and we respect the law.
Well, and if you juxtapose the right to get for same-sex couples to marry and the desegregation issues with abortion, we have in desegregation we have massive oppression and racial just crazy things going on, and in same-sex marriages we have oppression of people's rights to get married, and we had a bunch of states that had already been working through to legalize that. So you've got a large critical mass that's showing society has changed, therefore the pendulum should swing. Makes a lot of sense. Look at this issue. You've got a lot of people on both sides of the issue. It's a very divisive issue. That's very true. Very polarizing, very high profile. But this isn't like we've got a massive amount of people that are being oppressed or having their social rights messed with. So this would not be a situation where the pendulum's going to swing just because we have a new conservative Supreme Court justice on the bench. And going deeper into your precedent idea, I think that you pointed this out earlier with the word fetus. Really what's going to have to happen, in my opinion, is that if we're going to see anything change, it's going to be, okay, well, first, there's going to have to be a challenge to narrow what privacy actually is versus what it isn't, which could come in something that's wholly distinct and different from
it could come
an abortion
in,
case.
I don't know.
Could come some communications, social media, some issues with...
It could be an issue about like an influencer, someone broke into her DMs and does she have fundamental privacy to her DMs? Something
like that.
Completely unrelated, except for the fact that it deals with the matter of privacy.
Right. So I think if you're going to see something change, so we're talking in the hypothetical that, what would it take to get Roe versus Wade to shift?
Yes.
One, I think you're going to have to see some narrowing on the right of privacy. And then two, I think you're going to have to see a change, like you pointed out earlier, in what is a fetus defined as.
Absolutely.
Is a fetus a person? You'd have to get a lot closer to that.
Yeah, you would have to narrow the gap between the concept of fetus is not a person, such that he or she is not eligible for the rights that all American citizens have, because they're not a person yet. And so we would need to see a narrowing of that, they are a person at 6 weeks or 10 weeks, or we find that they are a person for the matter of achieving due process at these certain situations or these certain levels. So there's this balance, right? Anyway, I'm not going to go into that. But
well, and what I want to point out, something that just came to me, though, is that it's important, is that people may say, well, a judge in the judicial system is not qualified to make that determination.
Because they're not a biologist?
Right. Now, I will say, and the good thing about that is, look at the opinion that was written here, where they listened and read through amicus briefs, which are briefs that are submitted by people who are not actually involved with the clients that are at the Supreme Court. They have an interest. They submit briefs.
And amicus, for those of you who don't read Latin, means friend in Latin.
Yeah. So it's a friend of the court, basically. It's like, hey, listen, we're interested in this issue. Think you should think about these legal issues.
Please take it into consideration.
So for Planned Parenthood would be an example of an organization that would have an amicus brief, submitted.
Sure. Or a religious organization, right? That is very much opposed to abortion, perhaps like a Catholic charity or some such.
Exactly. And if you look at the opinion in Roe versus Wade, even back whenever this was written, they cite to a lot of doctors' opinions and doctors' thoughts and their analysis that is put into the brief of these amicus briefs that really, they go in and talk about, okay, well, this is what viability means, this is the dangers to the mother. And so when people say, well, a judge is not qualified to make that determination, well, it's not the judge sitting there thinking, well, you know what, I think viability means this. They're actually looking at a lot of things that make up how does the medical world define that. And so they're not making this decision in a vacuum. They're taking the time to go through and figure out, what does society really say about this? What medically is good on this? Or excuse me, what medically proves this? What do doctors say about this? And so they're doing a good job of really diving into that. And, kind of to talk a little bit about that precedent, the slow-moving piece, again, you're going to have to see slowly opinions change over time about the little pieces, which then can move the big piece. I know one of the analogies I always use is you've got a speedboat that's driving in the ocean, and it can turn on a dime, it can move around. You got a cruise ship, it takes a while for that to turn. The cruise ship is really what our Supreme Court functions like. Little changes over time can move it, and then eventually it can change direction, but it's going to take those little turns to get there. And so, Andrea, with the appointment of the confirmation of Justice Barrett, is that just going to end, in your opinion, the progeny of Roe versus Wade?
Absolutely not. The discussion is still going to be ongoing.
Yeah.
And I want to swing and I want to say something really quick. We discussed this earlier, was during the Senate confirmation hearings. I think a lot of people made a big to-do about the fact that Justice Barrett would not forecast her opinion on a potential case that dealt with the issue of abortion.
Right.
And so I just want to say, and I feel extremely strongly about this, y'all, there are these things called the judicial ethical rules, and these rules actually explicitly state that a judge or a justice in this situation is not permitted ethically to forecast her opinion on a possible upcoming case.
Yep.
So while I understand people are concerned, this is a very big issue, Justice Barrett was actually abiding by the judicial ethical rules by refusing to forecast her decision.
Right. And that's what you want. Mm-hmm. That's what you want.
You want a judge that abides by the ethical rules and abides by the rules of evidence and procedure. And she was doing that.
Yeah.
So whatever y'all's opinion on abortion, she was abiding by the judicial ethical rules that she is required to abide by.
Yeah. And look, congressmen and women and senators do what they always do, and they're going to use that as a way to, punish her whenever they don't want her to be on there. And everything they're saying about, well, she won't give her opinion. Why won't you give your opinion? She's not supposed to. That's not what we want. That's not what she's up there doing. You're using that for political clout, so your constituents think that you're doing your job. But that's politics, I guess. Anyway.
Yeah, that's politics.
So, and that's what we wanted to do. And just a few things. I looked up a little bit and did some research just on her opinions on abortion and what she thinks about it. And there's been a big deal about the fact that she's Catholic and a devout Catholic, and obviously Catholicism is highly against abortions as a doctrine, because it's you're killing a child in their opinion. And so there's been a big concern, okay, well, if she gets on the bench and she's conservative, then well, that's kind of neither here nor there, because she can't flip it in one way. And I think that she's quoted, there's a quote I wanted to read from her that I think sums up what you and I have been talking about this whole time, is that she says, "I don't think the core case Roe's core holding that women have a right to an abortion, I don't think that's going to change." She said in the talk, per NPR, she said, "I think the question of whether people can get very late-term abortions and how many restrictions can be put on clinics, I think that may change." So, and that's what we've seen in the cases we've had since Roe versus Wade, is that the challenges have been, is this restriction constitutional or not? And I think that's what we're probably going to continue to see, unless we get a change in what is privacy, what is a fetus, or whether a fetus is a person. I think that's the only way we're going to actually see something change, as opposed to just dealing with whether these restrictions are reasonable or not.
Yes.
So I don't think that everybody that's concerned about the pro-choicers out there that are concerned that, oh, it's over now, I think you're fine.
Yeah. And look, let me, you tipped your hand, I'm going to tip mine.
Yeah.
So personally, right, based on my own personal religious and faith-based views, for me, that is not something that I feel like, I would probably do personally, based on my own religious beliefs. But I can appreciate the situation that Justice Barrett finds herself in, is that she has her own religious personal views, which I think we might agree on what those are personally for ourselves. But as lawyers, and she as a justice, also understands that at the end of the day, as lawyers, we are sworn to uphold the Constitution of the United States. And our personal religious opinions and beliefs, and they're very fundamental and very important to us, cannot dictate our duty to uphold the Constitution.
Right.
And so part of upholding the Constitution is to apply the laws of this government as best we can.
Yeah.
And I think that Justice Barrett will do that, and I think she will do her best if and when a case is presented that touches on the issue of abortion. She will do her best to uphold the law and apply the law correctly, even if she personally disagrees with it.
Yeah. Yeah,
and I respect her for that.
For sure. And I think one of the things that struck me during the entire confirmation process is that you didn't hear a lot of the criticisms of her confirmation had to do more with the concept of President Trump rushing her in prior to the election. That was the louder voice. You really didn't hear a whole lot of people saying that she was unqualified or that there were big issues with that. And so I think that's one of the things that excited me about her getting confirmed is because people on both sides of the aisle were saying she's qualified. She's good.
She's absolutely qualified.
And I think that she's given, she's been coached, I'm sure, but she's given all the right answers about being able to divide those things. And that's what you want in a judge, is to keep that separation of church and state. I've tipped my hat earlier, but I'll just come out and say it so everybody understands. So I'm a very pro-choice person. I think Roe versus Wade was absolutely decided correctly. And I've actually gotten into numerous arguments on dates and stuff about this situation.
Yeah, I'm sure you have. I'm sure you have, yes.
And they don't really like the whole, the law says that doesn't work on a date. But when it comes to the way this was decided, it made sense to me. It sounds like we're both on the same page as far as the due process clause and applying the legal aspect to it and taking your religious beliefs out of it. And that's where you get a lot of the emotional opinions that come into that whole situation.
I will say I personally would really be interested in seeing a test case go to the Supreme Court that addresses the issue of viability. Yeah. Because I think that is the most subjective portion of the opinion. And I have my personal views, which we've already addressed, but I would be very interested in seeing additional cases brought before the Supreme Court that address the issue of viability and perhaps bring more, not necessarily narrow it, but bring more clarity to the issue. Absolutely.
No, I'd love to see that too, because I think that's where you're going to see, all right, are we going to see movement here, or are we going to see it move? Are we going to see movement towards abortion being narrowed, or are we going to see movement towards it staying the same? Well, excuse me, are we going to see it stay the same, or are we going to see it move towards maybe more unfettered rights to do that? Because that definition is going to get there. That's probably going to have a bigger impact than any expansion or contraction on privacy. I would think.
I would think so too.
Yeah. Well, we got to do a lot of law nerding out today.
We did.
I enjoy that because it allows you and I to kind of flex our muscles on it. But it is, it's important to understand the nuances. That's what's 100%. So important about these cases, because they shape policy, they shape laws, and they don't just do it with the overarching holding or the overarching opinion or main concept. They do it with the little pieces that they put in there as well.
Absolutely. And you know what, guys? Don't believe everything you hear.
Right. Right.
Just because someone says Roe versus Wade said this, take a moment. Yeah. Y'all are smart. Yeah. Y'all are very smart people. You wouldn't be, wanting and listening to learn if you weren't smart. So we know you're smart. So just read. Think about it.
Yeah.
Ask yourself why. Look into it. Y'all are capable. Y'all are brilliant. You got this.
Well, guys, thank you again for listening to #Lawyered. Stay tuned. We've got closing arguments actually talking about another Supreme Court issue and whether the Affordable Care Act will withstand its third constitutional challenge since 2012.
Dun, dun, dun. Hey, y'all. Thank you so much for listening to #Lawyer today. But wait, before you go, we want to make sure that you know where to find us on all the socials. So catch up with us on the audiovisual portion on YouTube. We have a #Lawyer channel there that we're very excited for you to take a look at if you want to put some faces to names. I know I love doing that. Make sure to follow us on our Instagrams, whether it be the #Lawyered Instagram or Austin's and my personal Instagrams. We check all three, so make sure to DM us or frankly leave comments on all of our latest posts to make sure that we're covering the topics that you guys are interested in. And if you have any questions or you're like, hey, I heard this in the news today, I think it's really interesting. I kind of want you and Austin to break it down for me and give the legal perspective so that I am well equipped at my next dinner party or Zoom cocktail hour, COVID and all that, to be able to discuss this with my friends. So again, thank you so much for listening. Make sure to rate and review the podcast on whatever platform that you're listening to. And we are so thankful that you're listening, and tune back in next week. Bye, y'all.
Today on Closing Argument, will the Affordable Care Act withstand its third constitutional challenge since 2012? Most analysts think so. The individual mandate portion of the act was challenged and argument heard on Tuesday, November 10th. And based on questions posed by the justices during the oral argument, many legal scholars believe they are leaning towards upholding the ACA once and again. The opinion is estimated to be released in June, and we will see whether the fear-mongering and gnashing of teeth over the appointment of Justice Barrett just before the election was justified or not.